Okay, I am streaming, but I have to be kind of quiet because I'm in the library and I have no study room to use. It looks like it's being used. It's this one right here, so you can see that. So that's my only option. This is this is very spontaneous, and I want to present some documents if I can. Let me get this in front more. And as you can see, I'm just kind of using a desk just to prop this up on. Okay. Oh. All right. There we go. All right. So I have some documents I want to share, and I just need a minute to pull them up. So I didn't get them ready ahead of time. Okay. Let's see what this shows. Okay. First of all, I find this interesting. Oh, I guess I need to save it. Okay, yeah, there's a couple of things I needed to do to prepare. Let me first ask, can I be heard? Is my voice hearable? Let's just take a test. Take a look at this. Is my voice hearable? Can anybody hear me? Type in this code. I'll type that in later. Alright, so I'm just kind of whispering into this, and we'll see how this goes. Okay, I want to save a particular picture and present that. Okay, and here's the save. And now I'm going to present it in OBS. Media source? Image. Is that... Okay, I've never really... It's been a while since I've presented an image. Let's see, I save it through Bandicam. Okay, there, yep. Down more. Okay, this... Let's see, how does that look? Alright. So, apparently, Cloyd is very proud of a win that he got 7 years ago. And this is on his LinkedIn. He apparently has a LinkedIn. And he's referring... Oh! Hey, didn't somebody just ask me to type that docket in? 15-199? Now I gotta look back. Just a second here. 15... Was it 15-19? Oops, down? Up? What? Oh, no. LCD E9E978. That's not it. If you ask me to type in 15-199, I would be surprised. But yeah, that's a case document that's searchable, and I have that thanks to Daniel Boquist. He picked that up. So I just need to get a picture. of that. Okay, take a picture. And, yeah, I do want to take that picture. But you know what? I want to put it in, I'll show it. But I want to put it in Photopea quick. Okay, image 2. Okay, browse all the way down. And there it is. Okay, but I'm gonna make another copy of that. So this is what Cloyd is referring to. But what's interesting, what was pointed out, was that his name is not mentioned on this. So how is he a part of that case? Let's see. Let me, oh, I gotta switch hands. I need some blood circulation. Photopea. Okay. And then I guess I don't need to do this. Nothing. What? I go to Bandicam and nothing shows up? Open from computer? That's weird. Well, whatever. People have had enough time to look at it in the state that it's in. Let me get rid of that. It takes too much time. So you could see that this is his document, or that he claims that it's he likes to lie a lot. So it's hard to believe anything he says. Okay, and I think I have a third picture. What was that third? Oh, nah, I don't need to show that. Somebody message him. Okay, let's see, we got those. Motion to exceed page limitation. Okay, I want to download this or not. Okay, not print. Download. Open. No. Open. Okay, just gonna open it twice. But at least looks different the second time. Okay. PDF to JPG. Okay, no. Okay. I really need this to just not be... Okay, we're gonna motion to exceed page limit. Okay. We're gonna open up window capture. No, yes. Window capture. That's the one. Okay. Now what's this all about? We got motion to exceed page limitation in reply to opposition. Undersigned counsel received an opposition to the application for a writ of review on 7/22 via email. In response, undersigned counsel has prepared a reply to opposition to application for a writ of review for filing that is 27 pages in length, not including the appendix. The first 3 pages consist of title page, table of contents, and table of authorities. The last page includes an affidavit and certificate of service. Just a second here. So let's rewind it. Okay, we'll continue on here. The only 23 pages of substantive content exist in the reply to opposition to application for a writ of review. Undersigned counsel has sought to succinctly address and rebuttal all of the many points contained in the 19-page opposition, necessitating extensive analysis and writing on these issues. The opposition contains many inaccuracies and errors or lies that must be addressed to ensure that the Third Circuit has an accurate understanding of the facts. If undersigned counsel is not allowed to exceed the page limitation for a reply brief to the city's opposition, defense counsel would be forced to eliminate substantive content addressing multiple errors. I'll be right back. Undersigned counsel has sought to succinctly address and rebuttal all of the many points contained in the 19-page opposition, necessitating extensive analysis and writing on these issues. The opposition contains many inaccuracies and errors that must be addressed to ensure that the Third Circuit has an accurate understanding of the facts. Here, let me move this. How's this? How's that look? Oh, Oops. Let me just... Yeah, whatever. Alright. Make that bigger. That in front. Here, let me make it look like I'm reading it. Oops. There we go. The far corner. And then... Yeah, there we go. Okay. If undersigned counsel is not allowed to exceed the page limitation for a reply brief to the city's opposition, defense counsel would be forced to eliminate substantial, substantive content addressing multiple errors and inaccuracies in the city's opposition. Due process of law will be enhanced if the Third Circuit is able to have an accurate understanding of the points in contention in the city's opposition. Accordingly, for the reasons... Whoops. Let's just keep it there. For the reasons presented, appellate counsel requests he be allowed to exceed the page limitation, requests that the reply to opposition to application for a writ of review be accepted by the Third Circuit for its consideration and review, and that this motion to exceed page limitation be granted. I certify that opposing counsel Clyde Benjamin with the Natchitoches Parish District Attorney's Office has been emailed a copy. Okay. Alright. I'll clip out of that. Let me get rid of that window. Let's see here. Now there's more. That was motion. Okay, I have another. Yes. Okay. I want to download and then open. Okay, yep. Alright. I have an invoice here. I want to remove... Well... I should probably make a separate... Nope. Okay. We got an invoice for the cost. So, here is an invoice. Alright. What does this say? That we filed with the Third Circuit a reply to Clyde Benjamin, the prosecutor's writ, and had to pay $50. Okay. Oh, and we got contact information. Okay. There's a convenience fee. So there's a subtotal $50 for the reply. And then there's a convenience fee. Okay. So that's an invoice for the most recent document filed. Paid $100 for that. Let's see there's another one. Reply to opposition to application for writ of review. Okay. It says this is the big one. But I saw that there's +1, 4 documents. Okay, am I showing anything here? Nope. Okay, there's 4 documents. Oh, we paid invoice for motion to exceed page limitation. Invoice for rebuttal to opposition. Okay. So, I paid $200. These are 2 invoices. Motion to exceed. Okay. Yep. That's motion to exceed. And then rebuttal. Nope. E-file. Extended page limitations. Is that it? Okay, that's no good. Okay, invoice. Dump. Separate. Okay. E-file. E-file. Let's see if this is. Oh, come on. Okay. I got extend and extend. The same thing. Okay. Then I want to do this e-file. And download. There we go. Okay. And okay, separate. It's probably only gonna want to let me open only one. Okay, so we got extend and extend. Okay, then I guess I gotta compare the invoice numbers. 3,775. Okay. Well, then that's not gonna do it. Alright, I gotta make sure. 3,775. Okay. So I want to look at this again. That's not it. I want to look at this. 3,774. Okay, that's the one I want. Okay, open, show in folder. How about that? E-file exceed. Okay, exceed. Oh no, it wants to open in Samsung Notes. But I don't think nope, that's not it. Exceed page. E-file invoice for rebuttal. Does that, I don't recall that OBS actually will recognize Samsung. Oh, there it is. Okay, this is 774. Okay. And it's in a folder. So I want 775, and it'll be this one. That's 774, 775. Did that just switch? Yep. Okay. So there's two invoices. I can't show them at the same time, but they both cost $100 each. We got invoice 775, which is $100, and then we got invoice 774, which is also another $100. So it's my lawyer is paying for a convenience fee. Now, is that something that is optional? What the heck is a convenience fee? He's being transparent about this. But wow, $200 just to file documents. That's crazy. $200 to file these documents. These are two separate invoices. And it starts out with $50, and then there's another invoice. Is that okay? 774, 775. I have two? No? Why is... okay, I just need to understand. Okay. What is this one? Are these the same thing? Answer opposition 720. Yeah, it's the same date, same case number. It's just what's different is the invoice 774. Okay, it's 775. Where is that showing? They're both in Samsung Notes. Oh, okay, I got it. Okay, that was on the email. Okay. Well, I want to get rid of that. So there's $200 that just simply involve responding to the prosecutor's response. $200 got involved with the fees. I paid, with these invoices, I paid 2 separate installments of $50 each for a total of $100 convenience fees just to reply to the prosecutor's response. So that's an extra this is an extra $200 that I mean that can be added on to the total cost of everything, simply because the prosecutor put in an argument against. So that's it. I thought that was I mean, it's no fun to pay. Let's see. And then there's the actual reply itself. The e-file notice, e-file invoice. Oh, come on. Alright, I gotta pull it up. Rebuttal with appendix, okay. And then there's the actual reply itself. Yeah, I can go right up there. So what does it say? We paid $200 for this. This is a $200 document that the Third Circuit has charged. Come on. What is, I have to, how do I, okay. Alright. Where does it begin? Table of contents. I can't hit the arrow key. Stupid documents. Can't even. Okay. Well, alright. United States Constitution, First Amendment, Fourth Amendment. They've mentioned a lot of amendments, some court cases, public utility and commission, rebuttal argument, the $200 rebuttal argument. The city asserted in its opposition that Rosalind Parker called 911 for the Natchitoches Police Department requesting an officer. This statement is wrong, since Librarian Parker never called 911 and instead called the police office number a non-emergency line. During cross-examination, Hines asked, "Do you understand that I'm the guy who was arrested after you called 911 from the library on January 22nd? And Librarian Parker answered, "No, I didn't call 911. I called the police office." The police office number is a non-emergency line, distinct from the emergency line for 911. Additionally, a review of the audio recording from Miss Rosalind Parker's call indicated that at no point in time did the dispatcher say anything suggesting she was the 911 dispatcher. In fact, the dispatcher specifically said in the audio recording from the outset, "Natchitoches Police Department, may I help you?" At trial, when questioned, Dispatcher Nakata Scott further stated, "We answer the phone. If it's a non-emergency call, we say Natchitoches Police Department, how may I help you?" As it has done in its opposition, the city erroneously referred to the call as a 911 call many times at trial, but saying that something is so does not make it so. Why is the distinction between whether the call was a 911 call or a non-emergency call important? When someone actually fears a mass shooting is about to occur and is legitimately scared, that person will call 911, not a non-emergency line as occurred here, and immediately communicate that danger and impending harm. After communicating impending harm, the operator does not then place that person on hold for 30 seconds, as has occurred here. These facts undermine Librarian Parker's assertion that she was legitimately scared and highlights the non-urgency of her alleged concern. The city asserted that she stated that the defendant was wearing a green army jacket and was holding backpacks. However, at no point in time did Ms. Parker use the word holding in her dispatch audio recording. She indicated in the recording that the defendant had some backpacks with him, but she did not indicate he was holding those backpacks. Furthermore, because the dispatcher never mentioned the backpacks to the officers, the backpacks do not exist for the purpose of establishing probable cause or reasonable suspicion. The dispatcher's dialogue with officers via radio transmission indicate that she did not convey knowledge of backpacks to the arresting officers. Unconveyed knowledge may not be imputed to the officers. Librarian Rosalind never mentioned backpacks in Officer Davis's body cam footage either when he first arrived at the library. The city asserted that under oath at trial, Miss Parker testified that she and her coworker Carlo Jimenez were both on the second floor of the library, where she observed the defendant with two large backpacks looking very angry, while she checked exit doors. At the pre-arrest stage, within audio recording between the dispatcher and police, and body camera footage of Officer Davis that showed a brief discussion with Miss Parker, nothing was ever uttered about Mr. Hines looking very angry. The only references to anger occurred at trial for the first time in the interviews done after Mr. Hines' arrest for the first time. It is legally irrelevant to the charged crime that Mrs. Parker, it was legally irrelevant to the charged crime what Miss Parker observed about Mr. Hines' demeanor if her observations were not conveyed to law enforcement officers prior to any detention or arrest, probable cause to make an arrest, or if the city's characterization of the encounter with Hines as a detention is accepted. Objectively reasonable suspicion must be determined based on what is known to the officers at the time of the arrest or detention. In any event, even if Miss Parker had somehow conveyed to officers at the time, at the pre-arrest stage, that Mr. Hines was angry, being angry is not evidence of criminal activity. People at a library may have a variety of innocuous and non-criminal reasons for appearing angry. They may be busy or focused and not want to be disturbed. They may not like the librarian's attitude. They may simply wish to be left alone. Being uncheerful does not rise to the level of probable cause or objectively reasonable suspicion of a crime. Tellingly, Jimenez himself stated, "Yeah, on the first floor, it was my other coworker, another part-timer. Her name is Emily, and she told us, yeah." I asked him how he was doing, and he completely ignored me. But I don't think anything of it, because people sometimes are mission-oriented. Big shrug. It is noteworthy that Jimenez was smiling wildly while offering this assessment of Travis's alleged anger, and Jimenez's exaggerated shrug at exactly 11:51 is in line with the argument here. The city made multiple references to Jimenez's trial testimony. However, Almost all of Jimenez's testimony at trial was legally irrelevant to the charged crime. Jimenez's video could not be legally admissible in the prosecution's case in chief on relevancy grounds. Jimenez's video, though, was legally admissible by the defense for impeachment purposes to show a lack of relevancy of the trial testimony of Jimenez. In fact, Librarian Jimenez was asked under cross-examination, "Did you make any statement to police before Mr. Hines was arrested?" And he responded, "No, sir." Jimenez reiterated at trial that it wasn't until after the arrest that he talked to police. Thus, Jimenez, by his own admission, admitted at trial that he verbally conveyed that he verbally conveyed no information to police. No information to police before Mr. Hines was arrested. These statements by Jimenez mean that all statements made in his post-arrest video would not have been known by officers prior to the arrest. Post-arrest or post-detention statements are legally irrelevant in determining whether the arrest or detention was lawful. One cannot attempt to bolster in an ex post facto fashion a determination of whether there was reasonable suspicion of a crime or probable cause of a crime, as appears to have been done by law enforcement in this case. The Jimenez and Parker video interviews both occurred days after the arrest and were solicited by law enforcement, as trial testimony from these witnesses revealed, and as the video interviews themselves demonstrate. Travis's objections at trial as to the admissibility issues regarding these after-the-fact video interviews should have been sustained, and they should have been excluded from consideration in the city's case. Opposing counsel wrote that Mr. Jimenez indicated that the defendant was looking for emergency exits cameras and appeared to be casing the place. Mr. Jimenez testified he was very scared for his life considering current events in the world. Mr. Jimenez testified he thought the defendant was putting together a gun. After these observations by Mr. Carlo Jimenez, Miss Parker called the police. After calling the police dispatcher, Miss Parker testified that she and Carlo Jimenez continued hearing very loud banging noises that sounded like the defendant was taking a lot of stuff out of the backpacks. Again, Jimenez's statement at trial are legally irrelevant in the prosecution's charged crime. What matters is not what Jimenez allegedly observed but failed to convey. Rather, what matters is what is known to the officers at the time of the arrest. There is no evidence that Jimenez ever communicated to the law enforcement officers before the arrest that the defendant was looking for emergency exits, looking at cameras, appeared to be casing the place, or caused banging noises. He stated at trial that he did not communicate with them prior to the arrest. In any event, even if assuming for the sake of arguments, Jimenez had communicated these details, they would in no way support any finding of objectively reasonable suspicion or probable cause supported by corroborating facts of a crime. Looking at exits is not evidence of any criminal activity. Looking at cameras is not evidence of criminal activity. It is not clear how Jimenez would even know exactly what Travis was looking at. When one's head is turned in any given direction, one's field of view is wide, roughly 180 degrees. And if Jimenez claims that he saw Travis look at exits and cameras, what else was Travis looking at in his wide field of vision? Without Travis having pinpoint lasers emanating from his eyes and pointing to every looked at object, and Jimenez having the ability to read minds, Jimenez has no way of knowing what exactly Travis was looking at during any given moment, nor why. It is not uncommon to look around when visiting a library for the first time. In the end, Jimenez has only his imagination and speculation, neither of which are objectively reasonable, and neither of which were ever conveyed to law enforcement prior to the arrest. Appearing to be casing the place is so broad and ambiguous that it is not at all clear what that phraseology even means. Being very scared for one's life, thinking that one might be putting together a gun, and observing someone taking undescribed things out of backpacks as the city referenced Jimenez, is legally irrelevant to the charged crime. Fear, thoughts, and imagination do not equate to objectively reasonable suspicion or probable cause of a crime. Rather than relying on extremely vague phraseology, fear, thoughts, and imagination, one only needs to look at the actual evidence, or in this case, the utter lack thereof. No evidence of any gun was ever observed or found. No ammunition was ever observed or found. No parts of guns were ever observed or found, outright refuting any claimed fear of a gun being put together. No scope was ever observed or found. No threats by Travis Hines were ever alleged to have been made. The word gun, shoot, kill, die, or even tangential equivalents were never alleged to have been uttered by Travis Hines. No outlines of any weapons were ever observed in the innocuous backpacks that the city referenced. Nothing criminal or remotely criminal in nature was ever alleged by any witness to have been taken out of the backpacks observed. Vague things are not contraband. In short, no evidence whatsoever of any criminal activity was found or observed. Opposing counsel wrote that Miss Parker testified that given how the world is today, with people showing up in churches and public places, shooting, and the Boston bombing, which was based on a backpack, she was honestly concerned about the defendant's behavior and felt that she was being vigilant by contacting police. Being vigilant, however, cannot be used to justify an intrusion by law enforcement upon a person's existence. Being vigilant, however, cannot be used to justify an intrusion by law enforcement upon a person's existence. The Fourth Amendment exists for a reason. Vigilance must be exercised and examined within the boundaries of the law. Even more, the characterization by opposing counsel of Miss Parker being honestly concerned is inconsistent with Miss Parker's own actions and words. Librarian Parker called the non-emergency line, and Librarian Parker stated in her January 28th video interviewed about 6:55 minutes that she told officers Davis and Favors that they asked me, did we want him arrested or banned? I said no. I said I don't know he's doing anything. Likewise, Librarian Jimenez, whose testimony is legally irrelevant to the charged crime anyway, nevertheless stated in his video interview about 1,300 minutes that I'm like in my head I was making a scenario, in some Librarian Parker didn't know that Travis was doing anything, and Jimenez made up a scenario in his head. Both of these two statements eviscerate the city's case because these witnesses' own words betray the unreasonableness of their fears and imaginations. Their professed fear was ultimately uncorroborated by any objective facts indicating probable cause or reasonable suspicion of a crime. Finally, the librarians testified about safety and fear. Q is a component part of that particular position that you watch out for safety concerns of the library as well. Parker, yes. So you're obviously concerned with safety. Parker, yes. Mr. Jimenez, were you afraid? Jimenez, yes, very. Q, and again, what made you fearful? Jimenez, yes, and that made you fearful. Yet neither provided testimony that they took any action to evacuate the building. To evacuate the building. To evacuate the building. Yet neither provided testimony that they took any action to evacuate the building or otherwise protect any of the patrons of the library. Conduct completely at odds with the professed fear of a mass shooting. Opposing counsel discussed Officer Davis's testimony about an alleged pornographic image of adults seen in the defendant's computer when officers accosted the defendant. The discussion by the prosecutor must be dissected to reveal its internal inconsistency. Tellingly, Travis Hines was never charged by the prosecutor with any pornographic or sex offenses, nor was any such evidence ever found and retrieved on his computer. No allegation was ever made by any of the two librarians that Hines ever had any improper image or banner displayed on the computer. No pornography can be seen in any of the body cam footage admitted into evidence at trial, despite the allegations of the officers. Despite the allegations of the officers, most significantly of all, in a hypocritical and logically inconsistent fashion at trial and when questioning officers, the city repeatedly highlighted the claim by officers that they saw a single pornographic banner on a web page even after the prosecutor previously objected on relevance grounds when the defendant attempted to cross on this very topic, and even after the prosecutor's objection was sustained by the judge. If the city objected and was sustained at trial because it claimed that pornography was irrelevant to the case, and Travis Hines should not be allowed to cross-examine on the topic, how could the city then later credibly turn around and attempt to use that same evidence against the defendant when questioning officers at trial, and when presenting its opposition before this court? This type of prosecutorial conduct that was sustained by the trial judge is antithetical to due process of law. Evidence cannot be simultaneously relevant and irrelevant. So, no weight whatsoever should be given to this allegation in the opposition of an alleged pornographic banner being seen when the prosecutor himself objected to the relevance of cross-examination on this issue and was sustained by the judge. Despite the prosecutorial and judicial inconsistency on the topic at trial, even if one were to entertain Officer Davis's claim of seeing pornography, this claim is not credible. Davis described Travis's screen by saying, well, it was a majority white screen, about 2/3, and then the top had an orange banner, and on each side of the banner it had the bare posterior of two women, the one on the right showing her bare anus and bare vagina. On the left it had a similar image with a woman's bare anus and vagina, but it was engaged in a sexual act with a penis. And when asked, Q, okay, and you saw the porn? Davis described and answered, yes, sir, yes, I did. That's actually what's right here, and that was what the defendant is pointing at right now. The alleged pop-up appears to occur at 1:33 in Davis's body cam footage and closes at 1:39. When Hines moves briefly in a motion consistent with activating the camera's motion sensor and raising the camera's video image on the screen to capture the officers who have surrounded him. Travis's thumb is a prominent silhouette near the screen, in an image that is equal in resolution quality as any other available frame of video. There is no portion of what could be considered a banner on the screen that is any larger than Hines's thumb. It is unbelievable that Davis could see what he proclaimed to see in any area of the screen shown. No rational trier of fact viewing the body cam image could lend any credibility to Davis's testimony. Also, Hines made no effort to shield the screen, as it could have been done with a single hand according to the claimed image sizing as described by Davis. This failure by Hines to try to hide the screen is inconsistent with the allegation made by Davis that he saw a pornographic banner. Most tellingly, Davis and the other officers never mentioned to Hines that they saw a pornographic banner on the screen before they arrested him. As their body camera footage shows, they just saw such content prior to arrest. It is reasonable to believe that they would have questioned him about it. Opposing counsel discussed the formation of a supposed protective group around the defendant. This euphemistic phraseology masks the reality of what the officers actually did. They arrested Travis Hines without probable cause by preventing him from not leaving and interfering with his freedom of movement. And they testified to this reality. When officers wrongly arrest an individual, as happened in this case, they are not protecting that individual, but rather are acting in an authoritarian manner, and no amount of euphemistic phraseology can conceal this fact. Opposing counsel discussed the defendant's attempt to secure counsel in his defense. Opposing counsel stated that the defendant later states that he had trashed the application. The word trashed in its context is a verb that implies intentional action. This statement by the prosecutor is inaccurate. Mr. Hines never said that he trashed the application, but rather stated the application was trash, as in not in good shape, as he clarified, and that he had the application. A paper application can easily get wrinkled, torn, or damaged in multiple ways without being deliberately trashed. Paper as a medium is easily damaged. Opposing counsel is wrong in trying to insinuate that the defendant threw away the application. It would make no sense for the defendant to deliberately throw away the application and then file a motion and have a hearing to obtain a lawyer. Opposing counsel wrote that the judge contacted the public defender's office. The office indicated the defendant did not qualify for services. Likewise, the prosecutor wrote that on his own accord, the judge simply contacted the public defender to find out that the public defendant's income exceeded salaries and assets limits that preclude free representation. Neither of these two statements are supported by any evidence in the record. Opposing counsel failed to address defense counsel's argument in the application for a writ of review addressing this issue. Additionally, the judge misapplied 14-148, which specifically states its purpose as implementing Article 1, Section 13 of the Constitution of Louisiana. The judge read statutory law to take responsibility out of the court's hands, which was neither what was intended nor actually legislated. The judge never elicited evidence of any kind into the record to resolve the conflict between the defendant's assertion that he was indigent on the one hand and the alleged assertion by the public defender's office that he was not on the other. No one for the public defender office was called to the witness stand at the evidentiary hearing on the demand for court-appointed attorney motion to verify the judge's hearsay assertion that he actually called someone from the public defender's office. No one from the public defender's office was called to the witness stand to provide detailed testimony as to why the application was denied. Travis Hines was never questioned by the judge in a colloquy about his assets and liabilities. No specific reason by the judge, the prosecutor, or the public defender's office was ever given at the hearing as to why Mr. Hines was not indigent. No copy of the application requesting counsel was introduced into evidence at the motion hearing. Mr. Hines asserted that he was poor and is a homeless individual who lives out of a car, traveling from place to place, making a meager income from YouTube. The trial court making a single phone call. The trial court making a single alleged phone call to the public defender's office and being told that the application was denied is insufficient grounds for denying an individual the right to the assistance of counsel. A conclusory denial without factual support is not enough to deny someone the constitutional right to the assistance of counsel. Under the prosecutor's reasoning, if the public defender's office wanted to deny every applicant, it could do so because a denial would in itself be the final word on indigency. Then a mere unsubstantiated and alleged phone call confirming a denial would be all that it would take to deny every indigent person the assistance of counsel. No corroborating evidence at a hearing would be necessary. No testimony at a hearing would be necessary. No weighing of the facts at a hearing would be necessary. In short, the conduct of the public defender's office would be judicially unreviewable under this reasoning. Surely due process of law demands more. The promise of Gideon v. Wainwright cannot be turned into a mockery. The prosecutor further stated that, moreover, during the pretrial stages, the defendant obviously amassed some resources to maintain a YouTube channel. A person can still be indigent and have a YouTube channel. Mr. Hines is a homeless person who makes a meager income and drives around the country in his car making YouTube videos to earn a subsistence living. The definition of indigency is not unemployment. A person can be self-employed. A person can be self-employed and still be indigent. Everyone has some resources, no matter how poor. Even homeless people may have a tent and some clothes. Even homeless people may have a tent and some clothes. Whoops. The prosecutor wrote that the defendant did not qualify, and of course, in the end, as counsel asserts in his filings, that defendant procured plenty of GoFundMe account money to pay counsel to file this appeal. The prosecutor appears to not understand GoFundMe. Defense counsel already explained in detail that GoFundMe is a website where people can make charitable donations to support a cause. As previously explained to the trial court during the 5/20/2022 hearing and in post-trial motions, Robert Parker, a friend of Travis Hines, started a GoFundMe campaign online to raise money on behalf of Travis Hines to secure a lawyer. Once Mr. Parker learned Mr. Hines had been convicted, all of the donations went to Parker, and Parker sent them directly from Parker's bank account to undersigned counsel's account. Travis has never had possession or control of the GoFundMe donations. Mr. Hines was sentenced to jail after his conviction and was in jail at the time that the online campaign was created and obviously unable to access the internet. Mr. Parker and others were shocked, as Parker more fully described in his affidavit supporting defense post-trial motions record, in belief that a miscarriage of justice had occurred. Charity is not income. Contrary to the prosecutor's assertion that it is simply disingenuous to raise this argument given defendant's pre-trial shenanigans, it is disingenuous for the prosecutor to equate GoFundMe charitable donations as income in an indigency analysis when A, defense counsel has already explained on multiple occasions what GoFundMe is, and B, when cursory Google search will yield plenty of material how GoFundMe works to anyone who takes the time to learn. There is no excuse to keep repeating the blatant mischaracterization of GoFundMe as an income source. Donations from GoFundMe were made post-trial. This reference to GoFundMe is a post-trial deflection from the pre-trial and trial issue in question. Was Travis Hines indigent at the time that he requested the assistance of counsel prior to trial? He asserted that he was, and no evidence was introduced to rebut that assertion. The prosecutor stated that the defendant, Travis Hines, has a YouTube channel. The trial judge admonished defendant after seeing evidence that defendant harassed witness Rosalind Parker by making harassing comments and disclosing her personal information provided during discovery. This statement in the opposition is false. no evidence was ever introduced against the defendant to show that he harassed Rosalind Parker, or anyone for that matter. While some YouTube commenters, out of thousands of total commenters, made disparaging remarks about Miss Parker, no evidence was ever introduced to show that Mr. Hines ever harassed Miss Parker. It is not common for occasional commenters on YouTube channels to make disparaging remarks. This phenomenon frequently occurs on the internet. In any event, these statements by the prosecutor are legally irrelevant to the charged crime and are simply untrue. The city never redacted any information from the video before turning over the evidence to Hines. These statements about alleged harassment by Hines distract from the legal issues in contention regarding the charged crime and are not based on any evidence. The prosecutor stated that defendant omitted recording the court hearing February 15, 2022, against previous orders of the court and playing the video to over 17,000 viewers on the chat site. This is a misleading statement. The defendant actually stated of the original writ application, "Well, I made notes, a lot of notes." Then on page 96, Travis asked, "On what, like any device or any kind of device?" Judge Ousley responded, "That's what I'm asking." And Travis responded, "Yes." Travis clarified and reiterated on P99 that I made as many notes as I could. Travis never once admitted to recording a hearing on an audio recording device, as insinuated by the prosecutor. Regardless, this issue is legally irrelevant to the charged crime and cannot deflect from the fact that the city's case is not supported by objective facts. The prosecutor wrote, that defendant disputed the number of users commenting regarding his posting of harassing comments. Defendant indicates approximately an average of 7,070. This statement in the opposition is inaccurate. The prosecutor now compounds in his opposition his pretrial misrepresentation that Hines's video typically conjures an average of 10,000 harassing, intimidating, and violently belligerent comments. Pre-trial, Hines challenged that asserted astronomical number by stating that for most of his recent 20 videos, they averaged to 354 comments, so a minimum of 116 max of 739, sum total of 7,000. The comments counted were 7,000 total, 354 average. In opposition, the prosecutor now misrepresents to the court that defendant indicates approximately an average of 7,000. Hines stated at the pre-trial stage, as part of his defense to the claim of harassment, that in response to these 20 journalistic free publications for Mr. Hines, the average of 354 comments does not approach The 10,000 average Mr. Benjamin cites to this honorable court. Mr. Benjamin's brazen misrepresentation of this court is not his first, and we expect it will not be his last. The prosecutor wrote that defendant did not dispute the harassing and intimidating content. This statement is inaccurate. This defendant did in fact dispute that he harassed and intimidated anyone. He repeatedly denied having engaged in such reprehensible conduct. Travis even told the judge, "Yes, sir, and I did take that down." And when Travis learned in reference to one of his YouTube videos, some commenters out of thousands of overall commenters made disparaging remarks about a city witness, Travis also told the judge that he posted some of the discovery online to get help from others. Getting help from outsiders when you do not have the assistance of counsel is more than reasonable conduct. Tellingly, no charge of witness intimidation has ever been brought against Mr. Hines, because such a charge cannot even remotely be sustained. Again, injecting content about alleged harassment by the defendant is a discretion by opposing counsel in this case, and is legally irrelevant to the charged crime. The prosecutor wrote that there was no other reason to check all doors to the building. The prosecutor also argued with respect to librarian Parker that she indicated that she was wearing a backpack and had gone to exit and entry doors to check whether the doors were locked or unlocked. No evidence was introduced at trial that the defendant checked all doors to the building, whatever is even meant by checking doors. No evidence was introduced at trial to determine what was meant by checking whether the doors were locked or unlocked. No one testified or stated in the recordings that Travis tried to lock or unlock any doors. Checking whether a door is locked or unlocked is extremely vague. Are the librarians alleging that Hines looked at or physically manipulated a door? It isn't clear. In any event, an analysis of the city's case shows that 3 doors were mentioned in trial: the emergency exits by the DVDs, the door going to the stairwell, and the door on the 3rd floor. First, respect to the emergency exit by the DVDs. Jimenez said pre-trial he didn't even acknowledge the DVDs. He just looked at the exit, looked up and down, and then he did this, indicating nodding of head. Emphasis added. Jimenez echoed his statement as trial testimony. Parker contradicted Jimenez looking versus touching, and said pre-trial, and then he went over towards the exit by the DVDs, which is one of our emergency exits, and he kind of touched that door, indicating a light touch and stuff, and then he came back. Parker then contradicted herself in trial with, "I can't see the door from where I was. I can only hear." Second, with respect to the door going by the stairwell. In trial, Parker was asked about other doors, mentioning the door going to the stairwell. Parker said he kept going back to that one, but in her video statement, Parker had previously admitted that Hines just leaned his head in and looked up. And when I asked, open the door, she answered, well, the door was open. Third, concerning the locked door on the third floor at the top of the stairwell. The prosecutor argued that the complainant described that the suspicious person had attempted to gain entry to the third floor, which is locked in a restricted area. Pre-trial, Parker failed to mention anything about Hines touching or testing that door, or that she could even see Hines at that point. In the trial, Parker testified only that Hines went up the stairwell, without any claim that he reached the top of the stairs or that he touched the door. On cross-examination, when asked if she told the dispatcher that Hines was rattling the doors, Parker answered in a singular, "I said you checked the exit." The city asserted in its opposition that in fact Officer Davis's body camera footage captures dialogue of Miss Parker informing the officer again, or defendant's weird actions of checking emergency doors and restricting access to the third floor. Testimony arose at trial that Travis tried to go to the third floor, but this testimony is unequivocally contradicted by the city's own witness. Librarian Jimenez stated in his video interview that was admitted into evidence that Travis never went to the third floor. More generally, Jimenez was asked, "Did you ever see him try to access any areas of the library that are off limits or anything like that?" To which he answered, No, he mostly stayed on the second floor." Contradicting Librarian Jimenez, Librarian Parker said that Travis went up to the third floor realizing the door was locked and came back down. While Parker testified that the third floor was restricted, she never said that there was a sign or warning notifying patrons of new people to the library that the third floor was off limits. She also never testified that she ever verbally told Travis that he could not go to the third floor. A simple "sir, you can't go up there" would have sufficed. An individual, as Mr. Hines was, visiting the library for the first time, might easily think that the third floor, which was accessible via the same stairwell as the first and second floor, was a natural extension of the library. In any event, no evidence was presented that Travis engaged in any criminal activity on the third floor. No evidence was presented that he ever tried to open the door, break down the door, or commit any type of crime. This compendium of testimony about 3 doors, one of which was always open, cannot support the conclusion that Hines checked all the doors. There is in fact no credible testimony that Hines ever rattled or touched any door, despite the prosecutor's misrepresentation in closing argument that "I can't think of any reason why any person would run up to the third floor, shake on that door, and come back down. That's not exaggeration. Those are facts, and facts matter." This part of the closing argument was a falsehood because no credible evidence was ever put forth by the city that Hines ran to the third floor or shook any door. Rosalind Parker is not a believable witness, giving her testimony, her own contradictory statements, and given Jimenez's contrary statements. Even more importantly, many of these alleged details were never provided to the officers at the time of the encounter with Hines. These extraneous additional details are legally irrelevant to the analysis of whether there was probable cause for a crime, or if the city's characterization of the encounter is accepted objectively reasonable suspicion of a crime at the time of the encounter with law enforcement. The pre-arrest recordings are an exact record of what was said to the officers by Librarian Parker as admitted in the opposition at P5 lines 21 to 23, post-arrest statements, post-arrest videos, and trial testimony containing any deviations outside what was known to the officers at the time of the arrest are legally irrelevant in determining whether the charged crime was valid. Opposing counsel stated that, moreover, the defendant set up a recording and video device. It isn't a crime for a YouTube channel journalist or anyone to set up a recording and video device in a public library. The First Amendment protects such conduct. It was only after Davis arrived, as can be seen on Davis's body camera footage, that Travis then switched his laptop to video recording, and he repositioned the laptop to catch both Davis and Favors on the screen, given his unease with why they were surrounding him. Hines was at his computer where Davis cited him, and Hines maintained attention on his screen until Davis walked into the room. Davis testified only that Hines had his computer recording after he took down the images. These observations are perfectly consistent with the fact that Hines activated his laptop camera in reaction to the arrival of the officers, and not a moment earlier. Travis's quick response in bringing two cameras into action, laptop camera and GoPro, from his pocket, was nothing more than the action of an experienced journalist. This behavior is far from the setting up of camera equipment claimed by the prosecution, suggesting that Hines had some nefarious motive. Transparent actors should not fear or complain about recording and video devices in a public establishment. Citizens have a right to protect themselves by recording unlawful police conduct perpetrated against them. On page 9 of the opposition, opposing, hold on a second. The opposition stated that counsel Philip Adams filed a number of motions after having sought writs. The city court did not hear those matters due to divestiture of jurisdiction. This statement is inaccurate. Undersigned counsel filed a motion to enroll, a motion for post-verdict bail, defendant's motion for a new trial, defendant's motion for post-verdict judgment of acquittal, and defendant's notice of intent on behalf of Travis Hines. All of these post-trial motions were filed at the same time as defendant's notice of intent because of the rapidly approaching 30-day default period within which a notice of intent would have been filed if Travis Hines wished to have his conviction and any other related rulings reviewed by a higher court, and because of the timing in which counsel was hired. On May 5th, before the expected hearing on the post-trial motions, undersigned counsel filed a supplement to previously filed motion for a new trial and second supplement to previously filed motion for a new trial. Supplements are not motions. Supplements expand upon motions when new evidence is discovered, as occurred here under extremely tight time conditions. The judge and prosecutor both received a copy of these two supplements to previously filed motions. Additionally, the prosecutor himself emailed defense counsel in opposition on the merits to the motion, but did not file that opposition into the record, as was later learned by defense counsel. The prosecutor also argued that video shows defendant in area that is restricted and that is encompassed with bright yellow caution tape. This characterization of the magazine area as restricted is false. On Officer Davis's body camera at 12:40, Officer Favors had just passed through the entryway. At 12:40, Davis himself passed through the same entryway. The yellow tape is caution tape, consistent with ongoing construction of the uncompleted walls of the room. There is no "do not enter" tape as implied because this is not the tape's purpose. In fact, when Jimenez was questioned during cross-examination, you admit that Mr. Hines did not access any forbidden areas as you said in your statement, right? Yes, sir. And when Jimenez was specifically cross-examined about the magazine section that contained the caution tape, Mr. Jimenez, is the magazine section forbidden? He answered, no, sir. The prosecutor argued that police observed recording equipment, a backpack with unknown contents, and Officer Davis observed a computer with naked or pornography images in a public library space that unattended children frequent. Likewise, the prosecutor referenced the totality of the circumstances that children and the public at large were present. Again, the prosecutor argued at trial that pornography was irrelevant to the case, and the judge sustained the objection. So due process demands that this issue be excluded from consideration, since the defendant was denied the opportunity to cross on this topic and highlight the lack of evidence on this issue. The prosecutor's reference to children appears to be an after the fact attempt to bolster the original claimed fear of a mass shooting as being the basis for the claimed detention, actually an arrest, of Mr. Hines. This incident occurred on a Saturday when very few people were even present on the second floor, according to Carlo Jimenez. There was also no evidence introduced at trial that any children were present on the second floor of the library, although the city peppered the word children into its closing argument and its opposition. As the body cam footage shows, the children's section is located on the first floor, not the second floor. It would seem counterintuitive for a mass shooter to pick a weekend day with very few patrons present to commit a nefarious deed if the city's allegations of a suspected shooting is to be believed. It is telling that the librarians took no action to evacuate or otherwise protect any patrons, much less any children. On pages 18 to 20 of its opposition, it is unclear what the prosecutor is even arguing. This case did not involve a jury trial, so jury instructions did not occur. The prosecutor confusingly combines two defense assignments of error into the same argument and jumps between them. His argument is virtually impossible for defense counsel to understand. He lumps all the due process and confrontation issues discussed by defense counsel in the original writ application into one idea and summarily dismisses them by arguing that they are harmless error, without actually arguing why that is the case. Defense counsel reiterates the arguments made in the writ application and redirects the court back to those arguments. In totality, all of the errors committed certainly affected the substantial rights of the accused. There is no abundant reasonable doubt that the errors complained of did contribute to the adverse verdict of the reasons previously discussed in the writ application. On page 20 of the city's opposition, the prosecutor argues that therefore it has been shown that the defendant had more than 6 hours to confront witnesses and testimony. It is legally irrelevant how long the defendant spent confronting witnesses. 6 hours is not a legal standard. No amount of deflection can take away from the fact that the judge and prosecutor failed to follow the law with respect to the issues discussed in assignment of error number 3 by defense counsel. The prosecutor fails to address the merits of these defense arguments in the writ application. Without reiterating these arguments, they speak for themselves. Conclusion and prayer for relief. In conclusion, Travis's case is important, not because he has a serious felony with a serious punishment, but rather because his case implicates the contours of how government actors may exercise their far-reaching powers. Are law enforcement officers able to invade the affairs of an individual by arresting or detaining based on imagination, claims of fear, and claimed safety concerns alone? Or do we expect more of them in how we conceptualize probable cause or objectively reasonable suspicion as a society? The question is the crux of his case. Unsubstantial assertions cannot be sufficient indica of criminal activity. Oops. Objective and credible facts of criminal activity are needed to support an arrest. A homeless man's right to be at peace in a public library, free from government intrusion, when he has engaged in no criminal activity, is not all that is at stake in this case. If this case carries precedential value within the Third Circuit's jurisdiction, the freedom of future generations is at issue as well. It is important to be mindful of the principle that the right to be let alone is indeed beginning of all freedom. Public Utilities Commission v. Pollack. The facts of this case call for Travis Hines' conviction to be vacated. Alright. Let's see. Okay. So I am done reading this. I might have some more documents to read here. I just need to take a minute to look at my email. My email. I have to see what's in my email. What else is in my email? Okay, e-filing. Third Circuit accepts. E-court subscriber. Let's see. They just... Okay, the e-filing has accepted my lawyer's reply. Let's see. Google Voice Snap Kitchen. Stamped version for viewers attached. Okay, this is what got my attention. Oh. I think I know it. Oh no. Order. Oh, we got order. Be allowed. Okay, okay. Well, I already read that one. Let's see, and e-filed. Oh, I see. They got e-filed. I'll take a picture of this. I'll take a picture of this. Just take a quick pic. I think it's interesting because this shows that it was accepted. Just a little picture. Just that's all. Just right about like that. Okay, and now I should be able to just easily open up image. Okay, it'll be image, and I browse, and I find bandage. Oh, it's already. Yeah, right there. Okay. Okay, so I'm looking at. This is to signify that it was accepted at 8:30 p.m. They work that late? The court system works at 8:30 p.m.? That's crazy. Okay, let me see what else there is. Okay, and I'm just going to look at one more thing here. Okay, I'm not going to share. Okay, so maybe I can put it in the community. Okay, so I just read I just read the latest activity that's going on. We pretty much have wait a second. What happened to my video? Okay, so everything is filed that can be filed, and that's where it's at right now. So I'm going to stop this stream and we can carry on.